do I make a family member move out of my house? Whether it's a brother or sister or a boyfriend and girlfriend, that's a like, common issue or concern for people. And so you've got somebody that you might have invited into your home, brother, sister, could even be one of your children, and now you decide it's time for them to go, but they don't want to go. Caleb, what do you do to get them out?
Well, you have to file a lawsuit, unfortunately. It's called unlawful detainer. It's very much like an eviction, but it's separate action because there is no lease agreement, there's no rent being paid, and those are really the distinctions that separates it from an eviction. And we have this great new squatters law that's now effective, but it doesn't apply to family member, unfortunately. So if you have a family member in your property, adult son, anything like that, you're going to have to sue them for unlawful detainer to get them to leave.
And so sometimes I know that this has been done. You might have even done it before. As in all lawsuits, step number one is you pay the sheriff or a process server to put a copy of the lawsuit into the defendant's hands. Let's just say you're trying to make your adult son move out and he won't do it. You're still living in the home with him, and a doorbell rings as a process server, and they serve the papers on your adult son. Holy cow! I guess there could go either two ways. One would be the fireworks start going off, or the adult son, might be just a loser anyway. He might just go back in his bedroom and close the door. Who knows?
And that's a very important consideration. And I've had, both sides of the spectrum on that. I've had instances where the plaintiff has bought a actual body cam and worn it to make sure he wasn't physically attacked. And I've had other instances, like you said, where it's pretty much ignored, and the day comes where they have to get out.
And most lawsuits come with a 20-day summons, meaning that whoever the defendant is, they have up to 20 days to file an answer to this unlawful detainer action. And let's say the son is a loser. He goes back in his bedroom and closes the door and starts playing video games again. I'm being facetious, but I'm being somewhat serious too. And he just ignores his thing. 20 days later, what's dad going to do to continue to pursue this unlawful detainer action?
Well, the beautiful thing about evictions and unlawful detainer actions is we have something called summary procedure. Basically, the legislator decided possession of property is so important, we're going to shorten that 20 days to 5 days. So it's a 5-day summons in this case, which is great for property owners. And those 5 days go by. Now, that doesn't include weekends, and that doesn't include holidays. Those 5 days go by, and say son has completely ignored this lawsuit. You go to the judge and you say, first you go to the clerk and say, give me a default. And then you go to the judge and say, the clerk has given me a default because this son has not answered. Give me a final judgment. And the judge gives you that final judgment, and that's the end.
Caleb, I want to go back for a minute. When you serve a copy of a complaint on somebody, I think the law says that you can, when the process server comes to the door, that they can serve it on the actual defendant, or they can serve it on any family member, adult family member that's also living in the home. Could the process server in this situation serve it on dad, even though dad is a plaintiff?
I would never do that because you have a big conflict of interest there.
I would think so.
Again, the great thing about these unlawful detainer actions is, say son never answers the door, there's built into the statute you can make 2 service attempts for these unlawful detainer and eviction actions, and if they don't answer the door, you can simply just post it on the door and it's considered served, and that is only for these actions.
And just out of curiosity, if you're working with dad, would you say, okay, process server, tape it to the front door or tape it to the son's bedroom door? Just out of curiosity.
Tape it to the front door, most likely.
Okay. So the 5 days has gone by. The son just continues to sit in his bedroom and play video games. I'm being facetious, but I'm kind of being real too. And so now we get this writ of possession. And so the process server comes out again to serve the writ of possession on the son, and tries to hand it to the son, but also allows him to tape that writ of possession to the door, I believe.
That's right. So the sheriff is going to come out with, first, they're going to come out with a 24-hour notice. And it's taped to the door, and it basically says, hey, with 24 hours or later, I'm going to be back, and you will have to leave this property. And then the sheriff sometimes will come back in 24 hours. Sometimes they're really busy, and it'll be a few days. But when they come back, they will peaceably escort the son out of the property.
So dad needs to be standing by to, number one, let the people into the house and into the son's bedroom. And the sheriff is not going to move the son's stuff out on the curb, but the sheriff will stand by and keep the peace while dad has some movers put son's stuff out on the curb.
Absolutely, and make sure you have the locksmith ready in there as well.
Okay. Now, people may be out there thinking, oh, man, this is crazy. That could never happen. No, dad would never try and, evict his adult son out of the house. I guarantee you it's happening.
Oh, yeah, I have a lot of cases. Drug-related is the most frequent one for children. I have a lot of girlfriend, boyfriends who are not quite married, but they're older and the relationship breaks down and they won't leave. Those are really the two main situations.
And in that situation, the dad is, they go into the son's room and there's some furniture in there, and some of that furniture probably belongs to dad, always did belong to dad, but son's got his video game all set up and he's got some clothes in the closet. Hey, that's a situation where you're putting out on the curb his clothes and his video games.
That's right. Most of those situations, the son's going to take his game console. Anything that's important to him, he has it when he leaves the property.
Yeah, hopefully a wallet and a couple dollars in his wallet,
Right.
and out the door he goes. So that's an unlawful detainer action when it's not really a tenant. It's just somebody that happens to be living in your home that initially you invited them. It could be a brother, sister, child, or sometimes his boyfriend and girlfriend.
That's right, Tom.
All right. Hey, folks, my name is Tom Olsen. The name of the show is Olsen on Law.